Good morning again, Your Honor. My name is Doug Griffin, and I represent the Martin County School Board. I want to start by thanking you for your time and attention today. As we go through the day, we ask you to keep one overriding fact in mind. This is only a protest of the school board's decision on December 15th, 2009 to rank Pirtle Construction Company as the #1 firm with which the school board would negotiate a contract to provide construction manager at risk services for a project at the school board's Crystal Lake and Pinewood elementary schools, which had a budget of approximately $6.7 million in total. The core events in this case don't begin in 2002, and they don't begin in 2005. They begin on October 1st, 2009, when the school board published RFQ 080351-0-2009, which is the RFQ relating to the Pinewood and Crystal Lake elementary schools, and which is the origin of this proceeding. There are only a few critical dates in this case. The first one is October 4th, 2009. That date is critical because it is the time by which Urban was required to protest the terms, conditions, and specifications contained in the RFQ. As you already know from the pre-hearing stipulation, Urban failed to file any such protest. The reason that is so critical is that as a result, pursuant to 120.573B, Urban has waived any claims relating to the RFQ, including any provision governing the methods of ranking bids, proposals, or replies, awarding contracts, reserving rights of further negotiation, or modifying or amending any contract. The next core date you will hear about is November 12th, 2009, when the school board's Professional Services Advisory Committee, which you will hear me refer to from time to time as PSAC, met at step 1 to review the written proposals submitted by 13 construction managers at risk, to shortlist the number of applicants to 6 who would be invited to interview with the PSAC at step 2. Based on the pre-hearing stipulation and opening statement here, we understand that the protester may want to contest certain procedural and scoring errors at step 1. The problem is there's only one determinative fact relating to step 1. The only purpose of step 1 was to shortlist the candidates to reduce the number of applicants to 6, and the protester was approved as one of those 6 firms invited to interview. None of the scores carried over from step 1 to step 2 as a matter of fact, so no matter what happened at step 2, protesters suffered no prejudice. And as you know, Judge, in this kind of proceeding, the protester must make a showing that it was prejudiced, or to use the language of the statute, adversely affected by the agency's misstep. Absent the showing of some prejudice to protester, nothing else relating to step 1 is relevant to this proceeding. Then following step 1, we looked at PSAC step 2 meeting, which took place on November 23rd, 2009, when the committee met to interview the 6 shortlisted CMRs to reduce the number of qualified applicants to 3, and then to rank them in order of preference to recommend them to the superintendent and the school board. The PSAC conducted those interviews, and then, based on the 14 criteria in the RFQ, ranked the top 3 firms to be: number 1 was Pirtle Construction with 436 points. There was a tie at number 2 and 3 between the protester Urban and another firm called Cluin, each with 424 points. The interesting thing here is that Urban is not challenging the scoring of any of the criteria in the step 2 process except for one, which relates to the volume of work previously awarded to each firm. In other words, Judge, Urban is not contesting the scoring of 13 of the 14 criteria as scored by the PSAC. After step 2 in the process comes step 3, which is when the top 3 firms interviewed with the school board. That occurred at a workshop on December 15th, 2009. But before we talk about that date, I need to mention December 7th, 2009, because that is when Urban was issued a letter inviting it to present at the school board's workshop. And in that letter, Urban was informed that its presentation should be structured to address the 14 items noted in the RFP and should reflect emphasis to items with greatest weights. The reason that letter is so key is that the letter, coupled with the fact that all 3 firms making presentations, including the protester, align their presentations with the 14 criteria, resolves any doubt that the proposers knew exactly what they were being judged upon. No votes were taken at the workshop. Instead, the formal vote was taken at the meeting that followed the workshop that same evening. The school board voted 4-1 to rank Pirtle number 1 for purposes of negotiating a contract for CMR services for the $6.7 million Pinewood and Seawind renovation project. By the way, we have since learned, and you will likely hear, that our newest board member, Mrs. Barry Sorensen, did not apply the 14 criteria in reaching her conclusion. The irony, though, is that she was the one board member that voted against ranking Pirtle number 1, and she ranked the protester, Urban, as her number 1 choice. In the end, although Mrs. Barry Sorensen's failure to use the 14 criteria may have been a mistake, it was ultimately harmless to Urban. After all, she voted in favor of Urban, so once again, there was no prejudice to Urban by any such mistake. That is really the end of the story because, as you know, no facts developed after December 15th are useful because the determination of whether the school board had a reasonable basis for its decision must be made based on the facts available to the school board at the time it acted. But Judge, so far I've talked about what a bid protest should be about. Given the opening statement and the breadth of the allegations in the amended protest, I also need to talk about what this case is not about. First, it is not about whether the district has properly awarded any other CMR contract, regardless of whether such contract was awarded in 2002, 2005, or 2008. If someone wanted to challenge the awards of those contracts, they were required by statute to file a notice of protest within 72 hours of the publication of the intent to award for those contracts. That didn't occur, so any challenges to those awards have been waived. This is not a proper forum to collaterally attack previous awards that have happened many years ago. Moreover, if the protester is allowed to collaterally attack any part of the prior award, then it has a burden to prove that the ranking, in making that entire ranking an award, the school board acted in a manner contrary to the agency's governing statutes, the agency's rules or policies, or the solicitation specifications that were applicable. The protester must in addition establish that any agency misstep was clearly erroneous, contrary to competition, or an abuse of discretion. In other words, Your Honor, even if protester were allowed to challenge an award years after the fact, protester is not entitled to simply challenge one factor out of the award many years later. Protester has the burden to establish that the entire award was improper. Second, this case is also not about Morganti construction. Despite that the amended protest and even opening statement here and Urban's exhibits are replete with references to Morganti, the simple relevant fact is that Morganti was a proposer for this project, but it failed to be ranked in the top 3 by the district. Its proposal was rejected. Morganti isn't protesting the school board's decision. Accordingly, Morganti has nothing to do with this protest. Third, this is not about whether a protester approves of the fact that the scope of services for certain previous RFQs contain provisions for phased projects on an occupied campus to be completed in multiple phases over multiple years. Once again, a protester disputed the scope of services included in an earlier RFQ. It had an obligation to challenge that RFQ within 72 hours of the time that that RFQ was published. That didn't happen, so any such protest or challenge is waived, and this is not an appropriate forum to collaterally attack those earlier RFQs. Fourth, this case is not properly about alleged sunshine violations. This is not a circuit court, and DOA doesn't have jurisdiction over sunshine violations. Finally, this case is not about campaign contributions to school board members. Although the protester has now sullied board members' reputations by making the simple accusation in complete disregard of any factual basis. The ultimate proof of what this case is really about to protester can be gleaned from the voluminous news articles riddled with handwritten comments of Rick Bell, who was a representative of protester, that Urban sent the 4 board members who voted against Urban. You will see that the composite of materials can only be interpreted as scandalous political allegations. This case is ultimately about a contractor who, by the way, made his own his own campaign contributions, trying to create and leverage a political scandal in an effort to garner a $6.7 million contract. Thank you.